Your Honor, for the record, today is Friday, January 7th, 2022. The jury returned its verdict on November 24th, 2021. That verdict was that Travis McMichael was found guilty on all 9 counts in the indictment. Greg McMichael was found not guilty of count 1, which is malice murder, but guilty on the other counts 2 through 9 in the indictment. Mr. Bryan was found guilty only as to counts 3, 4, and 5, all felony murder counts, and the underlying felonies corresponding to those felony murder counts, which were counts 7, 8, and 9. The court asked all of us to look into, with regard to Travis McMichael, the issue of potential merger as to the malice murder charge. The state has reviewed its own indictment and notes that it charged Travis McMichael, who was found guilty of count 1, malice murder, a human being did unlawfully, with malice aforethought, cause the death of Ahmaud Arbery, a human being, by unlawfully chasing him through the public roadways of the Satilla Shores neighborhood in pickup trucks and shooting him with a shotgun, contrary to the laws of said state, the good order, peace, and dignity thereof. As the state notes, this encompasses 2 different actions. Unlawfully chasing him through the public roadways of Satilla Shores, which describes the actions they did in the pickup trucks, and then shooting him with the shotgun. As the court will recall, defense filed a demur to count 1, saying this was surplusage and should be removed. The state's argument was that the state was not going to argue it was an either-or situation, and that is not going to be the state's argument here. The state's argument here is that factually, the state believes that count 8, false imprisonment, factually has been eaten up by the way the state charged count 1 in this indictment. In other words, count 8 and count 6 would merge into count 1 for Travis McMichael on the malice murder charge because of unlawfully chasing him, meaning Mr. Arbery, through the public roadways of the Satilla Shores neighborhood in pickup trucks. The reason we believe that factually would merge is because count 8 is actually the false imprisonment charge. And count 8 does say, said accused did chase Mr. Arbery with a Ford F1 pickup truck and a Chevy Silverado pickup truck through the public roadways of the Satilla Shores neighborhood and did confine and detain Ahmaud Arbery. As the court is aware, the statute has nothing to do with chasing. That is descriptive language factually. The statute has to do with confining and detaining the victim. The fact that the state used up factually both the chasing in count 8 and the chasing in count 1 means both count 6 and 8 would then merge into count 1. I believe, and I could be wrong, but I will address this, that the defense may argue that count 7 and count 9 would also then merge into count 1 malice murder. However, the state's argument is that is not the case. The reason for that is count 7 is the aggravated assault with the pickup trucks. Did make an assault upon the person of Ahmaud Arbery with a Ford F-150 pickup truck and a Chevy Silverado pickup truck. An object, device, or instrument, when used offensively against a person, is likely to result in serious bodily injury. That, of course, factually can be a number of different things, and what the state did argue in closing argument was pulling up next to somebody, startling them, could put them in reasonable apprehension of receiving serious bodily injury. The state also argued in its closing argument that Travis McMichael, despite his testimony, actually used his pickup truck to pull in front of Mr. Arbery and cut him off, which caused Mr. Arbery on Burford to turn around and run away. So the fact that the jury found that they used their pickup trucks, objects which used defensively against a person are likely to result in serious bodily injury, did create an aggravated assault for Mr. Arbery, does not merge into count 1, which was unlawfully chasing him through the public roadways of Satilla Shores in pickup trucks. They are 2 separate and distinct things, especially when we have video evidence of the McMichaels pulling up next to Mr. Arbery then running away. That itself right there is an aggravated assault. He was obviously startled. He obviously was trying to get away from these men. They pulled up next to him, reasonable apprehension of receiving serious bodily injury. With regard then to count 9 is criminal attempt to commit the felony of false imprisonment. As the court will recall, the defense also demurred to that particular charge in the indictment. That particular charge in the indictment did have an "and" in it, which, as the court knows, is an "or," which the state explained in its closing argument to the jury. In this particular count 9, it did charge the defendants with unlawfully chase Ahmaud Arbery through the public roadways of the Satilla Shores neighborhood in pickup trucks and did attempt to confine and detain Ahmaud Arbery without legal authority on Burford Drive using a Ford F-150 pickup truck. In this particular instance, the state did argue and did inform the court in the demurrer response that it was going to argue and/or, because as we know, a criminal attempt is just a substantial step toward committing that particular felony. And as the court will note, count 8 took place on Holmes Drive, whereas count 9 was on Burford. So they don't have anything to do with each other. They're two separate incidents at two separate points in time based on the evidence in this case. So either one could be considered a substantial step, and because the "and" in between unlawfully chase and did attempt to confine and detain is really an "or" for the purposes of this, and once again, the state put that in its response to demurrer by the defendants, and the court denied the demurrer. That was filed by the defendants. The state also argued in closing argument that that was an "or." They could find it that he was chased. They could also find that on Burford they did attempt to confine and detain him, especially with Mr. Bryan's actions of trying to run him off the roadway from his driveway, and with Mr. McMichael's actions of cutting him off at the end of Burford. So in this particular instance, especially with the criminal attempt, it does not merge into malice murder simply because of the words "did unlawfully chase him through the public roadways" contained in count 1. Therefore, when it comes to Mr. Travis McMichael, the state's position on sentencing and merger is this: that he is looking at a life sentence on count 1, malice murder, that counts 2, 3, 4, and 5, all felony murder, would be vacated by operation of law. Count 6, which is the aggravated assault with the shotgun charge, would factually merge into count 1. Count 7 would remain standing, and count 7 is a potential sentence of 1 to 20 years on the aggravated assault with the pickup trucks. Count 8, in the state's opinion, would factually merge then into count 1. False imprisonment, of course, is a 1 to 10 potential sentence. And count 9, criminal attempt, cuts that sentence in half. So count 9, criminal attempt to commit false imprisonment, is a potential of 1 to 5 years. Therefore, the minimum sentence that this court could impose on Travis McMichael would be life with the possibility of parole with 15 years, and that court could suspend, probate, run concurrent with that particular sentence. The maximum, and that is what the state is asking for in this case, is a life without the possibility of parole. The state did file its notice of its intent to seek life without the possibility of parole back in 2020 when this case was first indicted. So the state is seeking life without the possibility of parole as to count 1. Counts 2 through 5 are vacated by operation of law. Count 6 would merge into count 1, leaving then count 7 and 9, which would be 25 years. We are asking that that 25 years be a 25-year sentence, but to be run concurrent if the court chose to impose a life without the possibility of parole sentence. And that would be count 7 concurrent with count 1, 20 years to serve. Count 9 concurrent with count 1, consecutive to count 7, thus making it a total of 25 years running concurrent with the life without the possibility of parole sentence on count 1 for Travis McMichael. And that is what the state will be requesting and seeking. With regard to Greg McMichael, he was found not guilty on count 1, malice murder. He was then found guilty of counts 2, 3, 4, and 5, all felony murder. The state is seeking, therefore, a life without the possibility of parole sentence on count 2, which is felony murder based on count 6, which is the aggravated assault with the shotgun. Counts 3, 4, and 5 would be vacated by operation of law. Count 6 would merge into count 2, the felony murder. In this particular case, that felony murder only alleges did cause the death of Ahmaud Arbery based on the aggravated assault with a shotgun, so we do not have the same issue with language of chasing in count 2 of this indictment. This would, of course, leave count 7, count 8, and count 9 available for sentencing. Count 7 is aggravated assault with the pickup trucks. That's a potential 1 to 20-year sentence. Count 8, false imprisonment on Holmes Drive, a 1 to 10-year sentence. Count 9, criminal attempt to commit false imprisonment, a 1 to 5-year sentence. So the minimum Greg McMichael is looking at is life with the possibility of parole and 35 years. That 35 years can be run concurrent, it can be probated, it can be suspended. The maximum Mr. McMichael is looking at, Mr. Greg McMichael is looking at, is count 2. The state is going to be asking for life without the possibility of parole. Counts 3, 4, and 5 are vacated by operation of law. Count 6 would merge into that life without the possibility of parole sentence, and the additional 35 years to be run concurrent consecutive, meaning count 7 concurrent with count 2, 20 years to serve. Count 8 concurrent to count 2, consecutive to count 7, and count 9, the 5 years to serve, concurrent with count 2, consecutive to count 8, resulting in a 35-year sentence to be run concurrently with the life without the possibility of parole sentence on count 2. With regard to Mr. Bryan was found not guilty of counts 1 and 2. He was, however, found guilty of the 3 felony murder counts, count 3, 4, and 5, based on aggravated assault with a pickup truck, false imprisonment, and criminal attempt at false imprisonment. The state is looking at a life sentence on count 3. Counts 4 and 5 would be vacated by operation of law. He was found not guilty on count 6. Therefore, count 7, the aggravated assault with the pickup truck, would merge into count 3, because count 3 is the felony murder based upon count 7. So count 7 would merge into count 3. Count 8, false imprisonment, potential 1 to 10-year sentence, and count 9, a potential 1 to 5-year sentence. Therefore, the minimum Mr. Bryan is looking at is a life with the possibility of parole sentence, plus an additional 15 years, which once again can be run concurrent, it can be run consecutive, it could be probated and or suspended. In this particular case, the state is going to make a recommendation for Mr. Bryan of life with the possibility of parole on count 3, with 15 years to serve consecutively on probation. And that is going to be our recommendation for Mr. Bryan. Your Honor, at this time, the state will go ahead and present its victim impact evidence for the court's consideration, and then once that's through, we will make our argument. Thank you. At this time, we're going to present Mr. Marcus Arbery.